Yes, you can sell your house before your divorce is finalized, but there are things that need to be in place legally before you do. And if you skip them, you risk your closing falling apart at the last minute, or worse, a judge holding up your divorce proceedings because of a real estate dispute. In this video, I'm going to tell you exactly how a pre-finalization home sale works in Florida, what your attorney needs to do before you list, and what I see go wrong when people try to rush this without the right team in place. If this is your first time here, I'm Amanda Sweetz, a realtor with Keller Williams Realty of the Palm Beaches. I specialize in divorce and probate real estate throughout North Palm Beach County. And this is part of a full YouTube series on everything you need to know about selling your home during a divorce. Let's get into it. First, a quick foundation. In Florida, any asset acquired during the marriage is generally considered marital property, and that includes the family home, even if only one spouse's name is on the deed. That means both spouses typically have a legal interest in the home, and both spouses need to sign off on any sale. You can't list the home unilaterally. You can't accept an offer without the other spouse's agreement, and you can't close without both parties signing. In Florida, both spouses must sign the listing agreement, the purchase contract, and the closing documents, regardless of whose name is on the deed. This is actually a protection for both of you. It ensures neither party can sell the home out from under the other. But it also means that if you're not communicating, the sale process can stall. So, what does your attorney need to have in place before your realtor can list the home? In most cases, there are a few things. First, a written agreement between both parties. Both spouses need to agree in writing, typically through a marital settlement agreement or a court order, that the home will be sold. This agreement should specify things like the listing price range, how the proceeds will be split, who's responsible for ongoing costs during the listing period, and what happens if one party refuses a reasonable offer. Second, authority to list. Your attorney can help establish who has authority to make decisions during the sale process and what happens if the parties disagree. Some couples designate one spouse as the decision maker for real estate purposes. Others require mutual agreement on every decision. Having this spelled out in advance prevents conflicts from derailing the entire process. Third, clarity on the net proceeds. Before you go to market, both parties should have a clear understanding of what the expected net proceeds will be after mortgage payoff, commissions, and closing costs. That way, there are no surprises at the closing table about who gets what. I work alongside attorneys regularly to help establish these numbers early. A good comparative market analysis and net sheet go a long way towards reducing conflict before the home is ever listed. This is a question I get all the time. What happens if one spouse simply refuses to agree to sell? If both parties' names are on the deed and one refuses to cooperate, you generally have two options. Option 1, negotiate through your attorneys to reach an agreement. This is always the preferred path. It's faster, cheaper, and less adversarial than the alternative. Option 2, ask the court to order a partition or compel the sale. A judge can order the home sold as part of the divorce proceedings, even over one spouse's objection. This takes longer and costs more in legal fees, but it is an available remedy. A spouse cannot indefinitely block a home sale in a divorce proceeding. Courts have the authority to compel a sale. I always recommend trying to resolve this at the attorney table first. A forced sell ordered by a court often means a rushed sell, and a rushed sell almost always means less money for both parties. Here's the part that surprises a lot of people. Selling before the divorce is final can actually be a strategic advantage. For one thing, it allows both parties to walk away from the marriage with their equity in hand. No ongoing financial entanglement, no shared mortgage to worry about, no disagreements about who's paying for the water heater that just broke. For another, it simplifies the overall divorce settlement. Once the home sale is resolved, the attorneys can focus on other assets. In my experience, the home sale is often the biggest sticking point, and once it's off the table, things tend to move faster. There's also a tax consideration. Couples who are still legally married at the time of the sale may be eligible for a larger capital gains exclusion than they would receive as individuals. I'll cover this in more depth in the video on buyout versus selling decision, but it's worth flagging now. The short answer is yes. Yes, you can sell before the divorce is finalized, and in many cases, it's the right move. But it has to be set up correctly on the legal side, and it needs a realtor who knows how to coordinate with your attorney throughout the process. In my next video, I'm covering another question that I get constantly. Who gets to stay in the house during the divorce proceedings? That one gets complicated, especially when there's kids involved, or when the mortgage situation is messy. I'll break it all down. The free divorce home sales checklist is in the description. It walks through the steps that we covered today and more. Grab it, and if you're ready to talk about your specific situation, my consultation link is in there too. I'm Amanda Sweetz, and I'll see you in the next video. Until then, take care of yourself and remember, your next chapter is your best.